My name is Jonathan Culbertson, and I'm the Compliance Manager at InCheck. Today, I will be bringing you the May 2022 edition of InCheck's Compliance Update vlog. Today's video will be highlighting a few recent legal updates that affect background screening as well as the hiring process generally. But first, I want to kick things off with a revision to a compliance update that I previously reported. In the April 2022 compliance update video, I mentioned that New York City amended the New York City Human Rights Law to require employers to include the minimum and maximum salary for a position in their job advertisements. I also mentioned that that law was scheduled to take effect on May 15th, 2022. However, the New York City Council passed another amendment that made three key changes to the law, among other things. First, the amendment clarified that postings for employment must also include the minimum and maximum hourly compensation when applicable. Second, the amendment stated that only employees may bring action against their current employers for an alleged violation of the law. And third, and importantly, the amendment prolonged the law's effective date until November 1st, 2022. Okay, now let's take a little bit of time to discuss the latest state to pass a recreational marijuana law. On May 25th, the governor of Rhode Island signed into law the Rhode Island Cannabis Act. The act addresses recreational marijuana in the workplace. The act states that employers are not prevented from refusing to hire, terminating, disciplining, or taking other employment action based on a person's violation of a workplace drug policy or because the person was working while under the influence of cannabis. However, the act does state that employers are prohibited from firing or taking disciplinary action against an employee solely because of the employee's private lawful use of cannabis outside of the workplace, as long as the employee is not working under the influence of cannabis. There are two exceptions to this provision. First, it does not apply to employers subject to requirements imposed by federal law or regulations. And second, this prohibition does not apply to employees that are employed in a job that is hazardous, dangerous, or essential to public welfare and safety, as those employees can be subject to a policy that prohibits use or consumption of cannabis within 24-hour period prior to their scheduled work shift. I'd also like to quickly mention that the act states that any person with a prior civil violation or misdemeanor or felony conviction for possession of marijuana that has been decriminalized subsequent to the date of the conviction is entitled to have that civil violation or criminal conviction automatically expunged. Next, I'd like to quickly feature two Fair Credit Reporting Act or FCRA lawsuits that are in the news. First, in Herbert v. Barnes & Noble, the plaintiff is alleging that the defendant employer willfully violated the FCRA when the employer included extraneous information in the background check disclosure. Specifically, the employer provided the plaintiff with a background check disclosure that still included the background check company's statement that the document was a sample and was not to be construed as legal advice. The defendant employer argued that there's no reasonable jury that could find the alleged FCRA violation was willful because the extraneous information in its disclosure was due to an inadvertent drafting error. Nevertheless, the California Court of Appeals is allowing a jury to decide whether the defendant employer willfully violated the FCRA. Next, the other case I'd like to mention is Schumacher v. SC Data Center. There, a plaintiff applicant alleged that the defendant employer violated the FCRA because the employer took an adverse employment action based on the background check report without first providing them with a copy of the report to allow them to contextualize and explain negative information that was in the report. Although the facts did establish that the employer defendant did in fact fail to provide the plaintiff with a copy of the background check report as required by the FCRA, the Eighth U.S. Circuit of Appeals ruled in favor of the employer due to lack of standing. The court reasoned that the FCRA does not afford consumers the right to discuss directly with the employer negative but accurate information in the report. And consequently, although the plaintiff demonstrated a bare procedural violation, they did not allege conduct that causes an intangible harm sufficient to confer standing. And last, we will conclude today's video with some guidance from the Equal Employment Opportunity Commission, or the EEOC. On May 12, 2022, the EEOC issued guidance entitled the Americans with Disabilities Act and the Use of Software, Algorithms, and Artificial Intelligence to Assess Job Applicants and Employees. The EEOC guidance discusses the 3 most common ways that an employer's use of AI decision-making tools could violate the Americans with Disabilities Act, or ADA. These 3 things are: first, employers may violate the ADA if the employer does not provide a reasonable accommodation that is necessary for a job applicant or employee to be rated fairly and accurately by the algorithm. Second, employers may violate the ADA if the employer relies on an AI decision-making tool that intentionally or unintentionally screens out an individual with a disability, even though that individual is able to do the job with a reasonable accommodation. And third, the employer may violate the ADA if the employer adopts an AI decision-making tool for use with its job applicants or employees that violates the ADA's restrictions on disability-related inquiries and medical examinations. Well, that's it for the May 2022 compliance updates. And I want to thank you as always for listening, and I hope to see you again next time for some more compliance updates.